And in this session, where I'm providing some two-camera material, I'm concentrating primarily on how to go about completing the first assessment piece. So here's the thing. For you Chuck Palahniuk fans, you might be aware of that saying. What am I after? I'm looking for you to devise a methodology that works for you in relation to putting together a way of solving legal problems in foundations of property law that tie together the law and the materials, which are extensive. What I'm ultimately looking for you to do is produce a document that you will be able to access when you leave the unit, even after you've completed the final exam. Now, why am I doing that? Because this is a foundation unit. It's a unit where I expect you to use the principles that you learn in this unit in other areas. So rather than find yourself in a year or 2 years as part of your studies thinking, I dealt with that instant, I dealt with that at some stage, but I can't remember where it was and I can't even remember what unit I learnt this in, I want you to at least leave this unit with something that provides you with a clear overview of what we've studied and how you go about answering the legal problems. It is, as I've previously described it, the starting point for a toolkit. For those of you that work with me in Introduction to Law, you'll know what I mean by that, and something that Scott Beattie developed, which I then adopted. So this is really quite useful in a whole range of activities, and I use it, and I'll explain how I use it in practice, or I did when I was in practice. So the key task of the first assessment is for you to identify key issues and to describe them. Now, there are many issues that arise in the first 4 weeks of the material, first 4 topics rather, weeks 1 to 5 of the unit. There are many issues, so you won't be able to identify all of them in the very tight word limit that you have, but I'm after the key issues, whatever they might be for you. And then to identify the process by which you answer the legal problems in relation to those areas of practice. So when you see something that requires you to identify, that means you're looking to find and then explain material. And in this instance, it's a process which suggests that you may need to consider lists or flowcharts, things of that nature, something that will provide you with clarity of thought, which is expressed on paper in terms of this area of practice and the key issues that you've come across. Of course, whatever you produce must be professionally presented, and I encourage you to include links where necessary. So if you refer to some legislation or a case, provide a link in the Word document that you produce to the authorised version, preferably. So why are we doing this? Well, it's something that you will use for the take-home paper, which was going to be an exam. It's now a take-home paper. And it's something that you'll use beyond this unit. So it's a way of dynamically reading the material. By that I mean, when you have a textbook, the size of the text that we've prescribed for you on this occasion, obviously it's daunting. How do we dynamically read the material, and what's the relevance of that to this first assessment? Well, by dynamic reading, it's really a staged process. The first is that you should, as always, for example, if you're looking at legislation or a case, try to get an overview first up before you delve deeply into the material. So when you receive a large textbook, look at the chapters, the parts, look at the way in which it's broken up, get an idea for where this is all going based on the headings and the overviews. The same way that you look at legislation. You remember, of course, the basic rules of statutory interpretation. Consider the Act as a whole. consider the overall provisions, and then delve down. Same thing when you're reading a textbook. So get a feel for the whole thing, and then that's for stage one. Stage two is, I would think, speed reading. I often use a highlighter, but if you do use a highlighter, ensure that you highlight something in a way that is readable as a sentence within itself, so that when you read the highlighted material, you can read it quickly. You're not stopping to understand what it is that you've highlighted. So in the speed reading process, you can just go through the material without a pen or a highlighter, or you can highlight. Now, of course, those of you that want to resell your text, you may not wish to highlight for obvious reasons. But you go through the material, you get a feel for it, and you probably sit on that for a while. And then at a later stage, you go through your detailed reading process. Now, you probably say, I haven't got time for all this. But bear in mind, the first few stages shouldn't take you too long, and you're not looking to absorb it all in detail. You're looking to get a general idea, get a feel for the material, get an idea of where the emphasis is, and get an idea of where to focus your attention primarily. Now, the detailed reading can be either all of the material, or it can be, as you see fit, some of the material that you've identified as the most important. So as you're reading the material, you're comparing it with the study guides, you're comparing it with what I'm talking about during the online sessions, you're getting a feel for what are the key issues, which is part of the first assessment. I identify, then describe these key issues. And if you're coming to describe the key issues, the part that you've highlighted or the extracts that you've made as you go might be useful as a starting point. Now, what do I mean by dynamic reading? Well, dynamic reading is that reading which you undertake in circumstances where the dynamic reading is that where you are looking at the material in a dynamic way. And that might seem fairly obvious, but what do I mean by that? Well, I mean that you're reading it with the intent of using it in answering a legal problem. In order to answer a legal problem, typically you need to identify the source material, and from that you need to identify a process. The process is the process that you'd use to answer legal problems relating to the area of practice, which is the second part, the second key part of the first assessment material. So when it comes to answering the first assessment, there are 5 components. You've got a very short word count. So some of the material you can include, but use it in footnotes or an annexure. So firstly, and I'll just run through the 5, 6 points in the assessment, and then I'll go back and talk more about what I mean by the process of identifying the key issues and identifying the process for answering legal problems. So on the first assessment, you've got 6 parts. Number 1, reading the prescribed material. All I need is for you to declare just a statement, not a statutory declaration, but just a statement. I have read the prescribed and the supplementary material. If so, to what extent? You can go further and identify the dates that you did that or something to that effect. But I just want you to say, to me, this is what I've read in terms of the prescribed and or supplementary material. So it's an honesty system. I'll take your word for it. It'll become apparent if you haven't at some stage, I should think. Number 2, attending live or viewing the lectures. So if you viewed this to camera session, just make a note of the date. Likewise, if you've attended live or the other sessions, just make a note of the date, or even just declare that you've done it. If you tell me in the material, I've watched every session that was recorded, then I'll take your word for it. But I want you to do it. The third is, and with that, if you want, I don't mind if you put in the footnote the dates or you put as an annexure to the material, these are the dates, this is how I did it, whether it was live, whether it was recorded. So you don't need to fill up the body of the text with some of the detail here is the point. Number 3 is the reading or the prescribed or other reading. So if you're able to access other materials beyond the prescribed material, then include a reference to that, include an external link to an article, for example, or a case, something else. And again, I don't mind if you use some annexures for some of these. Number 4, contribution to unit discussions. So generally it would be cut and paste. So if, for example, you've involved yourself in some class discussions, you've answered some questions on Moodle, you've created a study group or something, just make a note of that. Again, what I'm looking to see is to what extent have you become involved in this unit? How involved are you invested are you in the process of learning? Now, 5 and 6 are the key areas. This is the body. This is really what I'm after for the assessment. Describe the key issues, identify the process to answer legal problems in relation to those things. So that's essentially the assessment task in a summary form. Now let's flesh it out and find out what it is that I want you to do. To give you an example, I'll talk about my own situation. So in studying law in the 70s, of course, we didn't have computers, they didn't exist. So everything was paper-based. It was in the law library. And as there is now, the vast material to cover. So a lecturer or a tutor might say, well, here's a relevant case. And it's up to you as a student then to read the case and take from it what you think is important. So at that stage, I started to develop questions and processes in my own mind, identifying the key areas. So that resulted in a paper-based document, which I then used to answer the final exam question. So back in those days, of course, there was no such thing as an open book exam. Everything was closed book. And it was important, and all you had was a 3-hour sit-down invigilated examination, paper and pen, with a series of legal problems, and you'd have to answer those legal problems. So it's been, in that sense, for me, drilled into the process of answering legal problems, an idea of, well, what are the key issues? What are the key processes that I can then transpose into a legal problem? Most recently, I was a member of the Mental Health Review Tribunal. And as part of that tribunal, I was confronted with what was not brand new area of law, but I certainly had to consider it in more detail than I was previously. So the first task for me was to identify the key pieces of legislation and case law, and then identify the key areas of practice, the key issues that I was likely to have to be ruling upon as a tribunal member. So, for example, it might be that in that jurisdiction, we were dealt with applications for treatment authorities, we were reviewing forensic orders, we were dealing with applications for approval for ECT, and those key areas, or so fitness for trial, so those 4 key areas, I thought, well, they're the key areas. How do we break it down from there? So in each one, you think, well, what's the most important, what's the fundamental piece of law, in that case, legislation, the Mental Health Act. So you identify the key areas, break them down into treatment authorities, forensic orders, ECT, and you overlay that with other information in relation to things like Human Rights Act and some of the key issues like the Presser test, which deals with issues around mental health and fitness for trial, etc. So it's a matter of categorizing all of this material, and then from that, asking myself some key questions that I'd want to either ask in a hearing, which is essentially inquisitorial in that jurisdiction, or have asked, or at least have an answer to in my own mind. So, for example, when it comes to a treatment authority, I might want to know, has there been a clinical report? Does the report indicate that the individual has a mental illness? And has the treatment criteria been established? That is, that the person has no capacity to consent, that in the absence of treatment, there will be serious harm to the person, etc. And is there any least restrictive way? So you don't need to worry about the detail, but you'll understand that I went through this process and reduced it to a series of key issues and asked myself some key questions and identified a process in my mind that I'd need to be satisfied of in dealing with these various matters that were before the tribunal. And in the document that I prepared, I had these listed with links to the legislation, to case law, to things of that nature, and actually use this during the hearings. So unlike others, I always, well, actually in the tribunal, it's the norm for the members to have computers, but in other jurisdictions, it's not. So the federal court does. Federal court judges have computers now, but in many other jurisdictions, it's paper-based. So, but I actually use these. So if I had an issue to do with a certain issue, a problem, I would then have links to the legislation or links to the cases so that on the run, I could access information and therefore answer questions. Same thing applied in court. So when I was in court, if I had a matter where there was a particular issue, I could fairly quickly, either on my feet in open court, access the legislation, which then had a link to the relevant case law, and answer the problem, the issue that was raised by the judge, or I may have had an opportunity to have an adjournment to check this and then come back 5 minutes, 30 minutes, an hour later, depending on the complexity of the matter. But the point is that what I did was dynamically read the material so that when I read the material, I was able to extract the important parts, catalogue it, have it linked to the key areas, and put it within the context of a process that made sense to me. And that's what I'm asking you to do in this assessment. Don't worry too much about the marks. It's only worth 10%. But what I'm asking you to do is to start thinking about how you will catalogue this vast amount of material and put it in a way that makes sense to you in relation to the key areas, both for this assessment, the initial first assessment, the final exam, and then beyond. In the context of what you're doing, and I'm almost finished, in the context of what you're doing, a key area, a key issue for you might be, for example, overcoming private rights and compensation for acquisition of property. This isn't an exam hint, it's just an example. So you might say, okay, in relation to that topic, there's a lot of material. Some of it's in the textbook, some of it's in study guides, some of it's external. How do I put all this together? Because in an exam, or even a take-home exam to a lesser degree, but in an exam, I won't have time to necessarily absorb all of this material at first instance. So what do I do? How do I go about doing this? So you identify the key issues and you might say, well, where is the law based on this? You might think, well, it's the Commonwealth Constitution is the starting point, section 51, subsection 31. So include that, have a link to it, and then perhaps identify some of the key words. And it may be in your process, you might think, well, I need to consider some definitions. I need to identify what I mean by private rights. What do I mean by compensation? What's the form of compensation? For acquisitions, what do I mean by an acquisition? Does that mean payment? Does that mean acquiring in whatever manner? And property, what's property? And so you may have some definitions. Now, of course, you may then refer to case law as well, so have links to that material. And it may be that at the starting point you think, well, a really clear statement about how this is all tied together comes from a case. You might say, well, Environmental Protection Authority against Rashley is a good case, and there's a good quote there in relation to what we mean by having access to water and whether that constitutes property, etc. So these are just examples. So the idea for you is to try to put this in a form that makes sense to you. So therefore, there's no template in terms of how to answer the first question. It's really a matter for you to come up with a way that works for you. Now, of course, the advantage of doing this is that at the end of the unit, you'll have something that you can walk away with and then refer back to quickly. So if in 2 years' time or 5 years' time, you think, I've now got to deal with a problem relating to the compensation for the acquisition of property. I started something in Foundations of Law. I've been building on that. So now, rather than go necessarily straight to the textbooks, I can go to my guide, which will give me some information to get me started, rather than being a daunting task of having to reopen textbooks that are huge. Like, I hope that makes some sense. Don't stress too much about this first assessment, is that it's only worth 10 marks. Of course, I'm taking this unit as a one-off for Dr. Nankaro. I may not have set an assessment with 10 marks, but that's what we have. And I think that the alternative, as I mentioned, for me was to ask you to answer a very discrete little aspect of the material. But the concern that I have is that if I did ask you that as the first assessment, then you might be tempted only to read that part and deal with it. I do want you to look at the bigger picture. That's the idea of the assessment and why I've made it so open-ended. Anyway, I hope that helps, and we'll look forward to seeing you in our class sessions. Bye for now.